Good morning, Mr. Zanini.
Good morning. May it please the Court. John Zanini for the Commonwealth. We're before you on the Commonwealth's appeal seeking reversal of a suppression order entered by a Superior Court judge. There are two intertwined issues here. One is involving the interpretation of the Special State Police Officer statute that deals with university police officers, and the other issue would deal with the application of the exclusionary rule if there was a statutory violation.
Mr. Zanini, can I just ask the counsel a question? And I should have done this beforehand, Mr. Zanini, and you don't have to give me an answer. Neither one of you have to give me an answer now. You can file afterwards. While I was general counsel at Harvard, the chief of police in the police department reported directly to me. I don't think that influences my take on this case, but if either one of you would like me to recuse myself, please don't tell me now. You need to think about it and consult your clients. Just let me know, and you can let the clerk know. Yeah. Okay.
Commonwealth has no objection, Your Honor.
Just a factual question before we get started. Can you tell me what triggered this this situation? As I understand it, the defendant was at a gas station, putting gas in his car. Was there something that happened before we get to the gas station? Did he do something on the campus? Was there some behavior, or did they just, for whatever reason, decide, let's check this guy's license plate and run it just and see what happens?
For whatever reason. Yeah. There's no precipitating event. So the officer just looks at the plate, says, I think I'll run that plate. He runs the plate.
We don't know. Okay. Well, all right.
I mean, it's not, there's a transcript, which I think the court has, where he doesn't describe any
Did you present
causal
evidence
mechanism.
at the hearing that the BU police officers are appointed special police officers by the state police colonel?
I think the officer testified to that effect. There was no document introduced to establish that
He testified to it, I gather, on cross-examination, but not on
I
direct.
believe so. So there was, and the reason it was on cross was because this was a surprise to the prosecutor. This issue was not raised in the motion, and she specifically tells the judge that at the end of the hearing, and that's why she asked for time to file a brief. So on page 32 of the transcript, the prosecutor says...
There's no dispute. I mean, no one's disputing that he was a duly appointed special police officer.
Well, I think defense counsel points out in his brief that there was no corroborative evidence. There's no certificate introduced. But Mr. Santisi, the motion defense lawyer, certainly says, well, Judge, if he's a special police officer, he's outside of his geographic jurisdiction, so the whole thing is bad from the get-go.
Right.
And the ADA says, this is news to me. I didn't, this is not in the motion prior to today. Can I have time to brief it? And the judge says yes, and then there's a supplemental briefing filed, which is in the Commonwealth's record appendix.
Now, I was perplexed that your reply brief for the first time mentions the exclusionary rule, which was never a part of your original brief. Does that mean that you are conceding that a special police officer is not a state police officer under 22C Section 10?
Well, I think that he doesn't have. It's a matter of interpretation that I think this court could reach, but you only reach it if there's application, if there's going to be application of the exclusionary rule as a result of the interpretation of the statute.
Okay, well, let's assume for the moment that we do reach it.
I think you should.
Is it now your position that a special police officer is a state police officer under Section 10?
No, I don't think he's a uniformed state police officer. But I do think that he has the powers, his own, the statute 22C Section 63 that governs the university officer says he has the powers of a regular police officer.
Within the environs of the campus.
Well, again, the environs is the issue. The statute doesn't say the word campus. The Hastings case that this court wrote in 1845 extended out from the National Theater to the environs. That's now been interpreted.
But there's no connection between this defendant and Boston University, as far as
Right,
I
as
can
Judge
tell.
Riley said, there's no nexus here. There doesn't look to be a nexus in the sense
But
of...
wasn't there a nexus in the Hastings case? The National Theater was the nexus.
You could interpret it as saying there is a nexus.
But
That's
there
correct.
isn't-
On
but
the-
we don't
On the other
have
hand,
one.
if you have a guy who's got cocaine and heroin, he's a block from the campus, and part of your duty is to protect either the patrons of the theater from drug dealers, perhaps, or the people on campus from drug dealers. You could say, well, then there is a sort of a nexus.
Boy, do you know how many people within a block of BU campus might have drugs in their pocket if you take
I
all
would
of
hope
BU?
very few. Those are illegal, Your Honor.
But what would the nexus be?
Keep hoping.
What would the nexus be? Just a
Right, the
general
nexus is-
crime-fighting?
To protect the good students and of the campus from the predatory actions of the drug dealers who are in the environs. And if you look at the appendix in page 26 and 27, this is part of the reason you really need to grapple with the issue. The Boston University Police Department, in their policy, includes in their standard patrol area, in Part 4, subsection 4 of that, or subline 3 actually, Boston University Medical Center and its environs. So this officer in this situation interpreted, he followed this policy, and he said, I'm only a block from the Boston Medical Center building, and I'm in the environs, and I'm going to do what it now says under Section 7. I'm going to make an arrest on a warrant. So in Commonwealth Appendix 27, there's Section 7, which says if he's authorized to serve criminal process, he can serve a valid arrest warrant anywhere in the Commonwealth of Massachusetts.
Aren't there some of the statutes about special state police officers in 58 through 66 or whatever, they have specific language about doing this. This one doesn't.
Yes.
So wouldn't one might read that as a negative pregnant or whatever the expression is?
Right. The exclusion of one is the
Yes.
inclusion of
Yes.
the other, or vice versa. Right. You could use that interpretive guide, but if we look at the statute, the statute says that these officers have the same power to make arrests as regular police officers, which
Keep
seems...
reading. Keep reading.
I agree. So the first step here is, well, that seems to mean they can execute warrants. They can make an arrest like a regular police officer, so they can execute a warrant. This is in the Commonwealth's...
But they didn't have a warrant
addendum
in
on page
hand.
18.
They didn't have a warrant in hand.
They didn't have a warrant in hand, but I don't think you need to have a warrant in hand in order to make an arrest.
Doesn't the sentence go on, have the same powers within the?
Yes, well, not within, but what it says, for a criminal offense committed in or upon lands or structures owned. So you need to decide, well, is Hastings and maybe the Young versus BU case a little off when they said, they went from in or upon in this case and in the BU versus Young case from the appeals court and said, well, in or upon means environs. And BU versus Young involved a young woman with a restraining order, and the defendant was across the street. Now, she was on the land of the campus. So it's possible you could narrow that and say, well, the criminal offense of violating the restraining order, she's standing on the property of BU, occurred on the property of BU. So there's a way to construe it. But again, their policy is, if you read their policy, everything the officer did, and if you read his testimony, he's just following their policy. He's executing their interpretation of the law and the cases. They cite the Hastings case.
Well, this isn't a case where he's being sued personally. I mean, the fact that it's their policy doesn't help us in deciding what the limits of the statute are, does it?
I would agree that the Boston University interpretation of their policy does not control the court's interpretation of the statute, but that's part of the reason why we're here, is the officer was, carrying out his mandate under their interpretation of the Hastings case and the statutory authority, and the Superior Court judge said, no, you went out of bounds. Once you went out of bounds, what he did then, to get back to Justice Gant's question, is he reflexively applied the exclusionary rule and said, you went over the statutory line, so ipso facto, exclusionary rule applies, which it doesn't. The exclusionary rule is a remedy that applies typically, first and foremost, only for constitutional violations. So there are some statutes that specifically provide for the exclusion of evidence, such as the wiretap statute, or part of 276 Section 1. But this statute does not provide that remedy. And the Constitution here, I would suggest, what the judge had to do once he said you're over the statutory line was to then say, does the remedy of exclusion apply? And the first step of that analysis is, was the Constitution violated? Which I suggest it was not, because there was a valid arrest warrant issued. So his
What was the
Fourth
arrest warrant for, by the way?
The officer's recollection in the testimony in the transcript is that it was for a motor vehicle violation. He could not recall the exact violation. But it was a
How
motor
does your
vehicle
theory
violation.
play out on the larger scale if this exclusionary rule doesn't apply? So would that be any officer who makes an illegal arrest? He isn't acting within his authority, so therefore you don't apply the exclusionary rule?
That would be one possible way it would play out. If there's a valid, and that's...
No, I'm talking about any officer, not just a special police officer.
Well, I would have a hard time imagining that any officer would, if in the situation where there's an arrest warrant, the regular police officer has the authority to execute the arrest warrant statewide. So the only time you're going to run into this issue with regular police officers is going to be when they're making an arrest without a warrant.
Right.
And if they're outside of their town, in the next town over, making an arrest without a warrant. And then you just fall back on was there probable cause? Was it hot pursuit? Was it a felony? Because anybody can make an arrest for a felony. We can all do that if we want to, although we don't. And then if it's a warrantless misdemeanor arrest, well, was there a breach of peace here? If so, it's a valid warrantless misdemeanor arrest, I think. And if not, then you get to, okay, here's a police officer who made a minor misdemeanor arrest outside of his jurisdiction. Do we apply the exclusionary rule? And there you would potentially have an Article 14 violation, although Article 14 doesn't seem to be violated in that situation. There's just a common law violation. But here...
Are you conflating the powers of the special state police officers with the powers of regular state police and local police officers?
No, because the statute specifically says they can make an arrest and have the powers of regular police, and it's just got the geographical limit.
What about the
So-
fact, what about the warrant in hand?
I don't think that you're required to have a warrant in hand to make an arrest. So I have cases from other jurisdictions that say you're not required to have the warrant in hand. In Massachusetts, we have a warrant management system which puts the warrants out electronically and says a copy is as good as a signed original.
Right, but that doesn't go to the warrant in hand, a copy at
There's
least.
also a statute, I think it's...
But you don't, in your brief you cite that, I know, but that doesn't answer the warrant in hand. A copy, he
Right.
didn't have a copy either in hand.
Right, and I think 276-28 says, an officer authorized to serve criminal process can arrest a person charged with a misdemeanor without having a warrant for arrest in his possession, if he has actual knowledge that a warrant is in full force and effect. So I don't think that under 276-28, if it's a misdemeanor, you need the warrant. And if it's a felony and you have probable cause, you never need the warrant because it's a felony. And I think the fact that you look on the system and it says there's a warrant there, it's either a misdemeanor or a felony. Now you have probable cause because there's a judicial official who determined there's probable cause and ordered a warrant to issue. So that's why there's no constitutional violation under the Fourth Amendment or Article 14. And in Virginia v. Moore, the U.S. Supreme Court said if there's no constitutional violation and the officer violates some state statute, there's no Fourth Amendment violation as long as you have probable cause to make the arrest, and we have probable cause here.
You know, if I could just go back, I gather you agree that this officer was not a constable because Section 10 doesn't apply.
I agree.
Okay. So I gather you also agree that if this officer basically on a Sunday decided he had some free time and was going to basically search for warrants and arrest people in his hometown, which wasn't Boston, that he would not be entitled to do that.
Well, maybe in Brookline, because parts of BU
Okay,
are
let's
in
assume
Brookline.
it's further, it's beyond.
Right,
Sutton.
if he went to Springfield and decided to run some plates and start arresting people, he's clearly beyond the geographic limits of his authority.
And the law says you can't do that.
Well, the statute says you don't have the authority to arrest someone unless they committed a crime in or upon
Okay,
campus.
but
Now,
he
if the
did,
warrant
he
for the
just-
guy in Springfield
Right.
was for a crime he
No,
committed on the
no,
BU
it's just, he's
campus.
just basically
Warrant
roaming
surfing.
and warrant surfing and figured this is what he does on Sundays.
Yep.
What deters him from doing that if we permit the fruits of that arrest to come in?
I would think that if you write a decision that tells the Boston University Police Department that their policy may, as interpreted by their officers, may be a little overbroad in this way or overgenerous to their officer, that the university will change their policy, and to the extent they wouldn't already discipline him internally, and he might cease to be a Boston University police officer, that's a likely outcome. They will not tolerate their officers going out and arresting people statewide, potentially to avoid liability, in part only to comply with the law, which they certainly have a duty to do and they're going to do. And I think the officer could potentially be subject to civil liability for going far afield from his lawful authorities and making arrests, particularly for non-felonies. I mean, any of us can make an arrest for a felony. If he's out arresting people for misdemeanors, then he's going to be subject to civil liability. So there are remedies in place. Those remedies address the statutory violation of crossing the border, and there is no constitutional violation here.
Mr. Zanini, I just want to make sure I understand your position, because I thought I understood you to, or I thought I heard you say conflicting statements. One is that the authority of one of these BU campus police officers to arrest by warrant exists statewide. And then the second one was, no, the warrant has to be executed in the environs of BU.
Well, no, it does exist I think it does exist statewide under their statute where it says they can make arrests as regular police officers for an offense committed in or upon land or structures owned, used, or occupied by the college. So if they have a warrant for a person who committed a criminal offense inside of one of their buildings, B&E, they can go execute that statewide. But if they have a warrant that, as Justice Gant said, is just, here's a guy who committed a crime in Springfield, I happen to be driving through Springfield, then the statute, as I read it, would not permit that officer to make that arrest.
Now, if this motor vehicle offense for which a warrant existed involved a motor vehicle offense that occurred in Springfield, why would they have the authority to make the arrest here? Because it was within the environs of the campus?
If there was a warrant for an offense in Springfield, right, I don't think that they, in that situation, that they do have that authority.
Isn't that this case?
That's
Isn't
what
that
happened
this case,
here.
though? That's this case.
But their policy says they have this authority to execute warrants, and their policy says that they're supposed to be patrolling the environs. So their policy leads the officer to the conclusion, I would suggest, a reasonable conclusion from his understanding of the policy, or
Not
in
just
good faith.
I don't mean not just the policy, but the decision of Young against Boston University.
Right, where he can go across the street, or actually in that case, the man was across the street. He doesn't find him for another 2 hours, some
But
distance
there was a
removed.
connection to
But there
Boston
was a student
University.
at BU who
Again,
was being
there was a
harmed.
link, some tenuous link
It
back to
wasn't so
BU.
tenuous.
But I think the key here is that the officer in good faith reads this policy, which refers to these cases. They've drawn up a policy. He thinks, I can execute arrest
But the
warrants,
policy
and I can
doesn't
do
give
it
him
statewide.
authority that he doesn't have. He can't have it just because the policy says it.
I would agree with that.
But then you just agreed, I thought, to Justice Spina's question, that if he, the officer, is driving around BU, I mean outside of BU grounds, but close by, and sees somebody who has a warrant for B&E from Springfield, you said he could arrest, or say a misdemeanor from Springfield, you said he couldn't arrest him.
Yes.
I would agree with that.
But isn't
The
that this
officer-
case? Isn't that this
because-
case? We
because
don't
then
know
you-
where the warrant is
Yes,
from
but
in
the
this case.
officer
Could have been
here
from
proceeded in
Springfield.
good faith.
And therefore
followed
you
their
don't apply the
policy, followed the
exclusionary
decision of the
rule.
court.
Therefore, you don't apply the exclusionary rule.
Yes,
That's
that's the Commonwealth's position.
But you would,
I-
but you
I-
do agree he doesn't have the authority to
Not-
arrest on this warrant,
By my reading of the statute, he does not, but I don't think he
contrary to
proceeded in bad
contrary
faith.
to the original brief that you filed.
Yes.
I would agree with that, yes.
Okay.
The Attorney Seeger was very persuasive on that point. I would also point out in response to Justice Spina's question, arguably a guy walking around campus with an outstanding murder warrant or similar warrant might be beyond the scope of this officer's arrest authority.
See, I
which is a-
I think I think that's covered, actually. That's the way I read it, but anyway.
I see my time is up unless there are further questions.
Thank you,
Thank
Mr. Zanini. Good morning, Mr. Seiger.
Good morning, Your Honors.
Seeger, Seiger.
It's actually Seeger, Your Honor,
Well, we'll go with Seeger.
and I also have no objection to Your Honor presiding over this matter.
Now, I have some concern in that the Commonwealth has changed its position, and you have not had a chance to do a surreply to the argument which he now says is his sole argument, which is the exclusionary rule.
I believe that the Commonwealth's reply brief can be answered very easily, Your Honor. This question about whether the exclusionary rule applies is answered, I believe, by Commonwealth versus Leon, which says very specifically that special state police officers are agents of the state. They're affiliated with the state. They're not just private citizens. And the exclusionary rule certainly applies. And I believe that Leon, back in 1982, was very specific on that point.
Was that a constitutional violation or statutory violation?
I believe it was a constitutional violation.
Well,
Your
that's
Honor.
Mr. Zanini's point. I mean, you may not agree with it, but that, as I understood it, which is to say, it's essentially and I don't question him that, I mean, I don't disagree with him that the origins of the exclusionary rule were constitutionally based. Now, there may have been, I don't know, was that map against Ohio or whatever the case is. I don't know, I just haven't followed the jurisprudence enough to know whether that bled over into statutory violations.
We have a motor vehicle stop. We have a motor vehicle stop by a special state police officer.
So you're saying this is constitutional?
But based on probable cause, motor vehicle stop based on probable cause,
Certainly, this is,
so it satisfies the Constitution. It's a stop based on probable cause. Isn't that the argument?
and therefore the rule of exclusion applies to a special state police officer. So he would be subject to the exclusionary rule as any police officer would.
No, what I'm saying, there's no constitutional, the point is, and maybe I'm just missing it, the point is there is no constitutional violation here. There's a violation of a state statute.
The stop is not
Yeah,
unconstitutional
stop is
because
not
it was based on
unconstitutional,
probable
and
cause.
the arrest is presumably not unconstitutional. This is a search incident to an arrest. None of that being unconstitutional. Unfortunately, this officer didn't have the statutory authority to do it. Some statutes actually provide for the exclusion of evidence that's obtained in violation of various statutory provisions. Do we have that here?
I never really thought of it in that term. I'd always thought of it as a constitutional violation. It is definitely a statutory violation. And I would point out that the officer who testified admitted that the policy did not authorize this action. This was a random license check, and that is, his testimony is very clear that his own policy did not authorize this particular action. And I would point out, Your Honor, I don't believe there's any real dispute here, that there really is no nexus at all between the defendant and any action.
I'm taking that as a given right now in thinking about the exclusionary rule, just taking it as a given.
If you had a regular police officer of the town of Brookline who arrested somebody for a misdemeanor, not a warrant case, but arrested somebody for a misdemeanor arrested somebody outside of Brookline's environs, and so there's a statutory violation or a common law violation, but there's probable cause, but not a constitutional violation. The exclusionary rule would apply, would it not?
It would. But the distinction here, the crucial
And so I'm agreeing with, so
Why would it apply?
why would?
an arrest based on probable cause by an officer who wasn't authorized to make it, why would the exclusionary rule apply?
I think the distinction is, Your Honor, that in the case of Barr, we're talking about a special state police officer and not a regular local police officer or state trooper. And that changes the entire complexion of the case.
Well, but if a state police officer had made this arrest, there would be no constitutional violation. Isn't that right?
That's correct, Your Honor.
So,
That is correct,
the
Your Honor. I
only
agree.
difference here is that you have an unauthorized person making an arrest that was based on probable cause.
That is correct.
So if there is no constitutional violation on those facts, why should the exclusionary rule apply?
I would suggest that it should apply because there was a very clear statutory violation.
I think
This
you
was
may.
not
I think.
authorized by the statute.
I think you may want to accept Justice Gantz's invitation, which I now say that you can do, which is you may want to see. I mean, Attorney Zanini makes an argument that says the exclusionary rule doesn't come into play unless the underlying conduct that's being questioned is constitutionally based. There's no question in this case that the underlying conduct that is being challenged is statutorily based. And I just don't know what has happened to the original jurisprudence, but you may want to take a look at that.
I would suggest, Your Honor, that the authority that may be most directly on point, because we're dealing here with a very narrowly defined issue. Can the special state police officer make an arrest off the territory of the campus to make a warrant, an arrest based on a default warrant? And I would suggest that the CMR, which I cited in the 16L letter, is directly on point as to whether the officer has the authority to do that.
I'm sorry,
The CMR, Your Honor, I missed it in my original brief. but
that's okay.
I filed a
I
16L
apologize.
letter.
I haven't read your letter, so I'll take a look at it.
Your
What
Honor,
is this?
it appears to be very
What's
clear.
the cite to the CMR?
The CMR, Your Honor, is 515 CMR, Section 5.07. And it's very clear and actually very emphatic, and it speaks directly to the issue before the court. A special state police officer serving an arrest or a search warrant at a location not within the statutory jurisdictional boundaries of the employing agency shall be accompanied by a sworn member of the department or sworn member of the local police department. It goes on to say in another sentence, and again, couldn't be more emphatic, in no case shall an arrest or search warrant be served by a special state police officer at a location not within the agency's jurisdictional boundaries without a sworn member of the department or the local police.
So someone may get fired as a result of this, someone may get sued as a result of this. The question is whether the exclusionary rule should apply to essentially a statutory violation, but the statute doesn't specifically provide that it will.
That is the question, Your Honor, and I would suggest that this is a very clear statutory violation. It's not authorized by the plain, explicit language of 22C, Section 63. And what I see here is the Commonwealth citing a number of statutes in an effort to construct an argument that the court may infer that this special state police officer has the authority to do whatever he wants anywhere in the Commonwealth. And clearly the authority simply is not there. And Section 63 is very
For purposes
specific.
of this argument, I'm agreeing with you entirely, and I'm just trying to figure out what the appropriate remedy is.
Have you researched cases in which a police officer from a different state makes an arrest in a state for which he's not a police officer? I mean, if a Massachusetts police officer goes to Connecticut and makes an arrest, do we have any, or
I think we have a
vice
case
versa?
involving town. I'm pretty certain we had a case involving a police officer from a different town.
Yeah, other than hot pursuit.
Yeah, I think we said other than hot pursuit, you can't do it.
I believe those may be hot pursuit cases. You're driving from Massachusetts across the border into New Hampshire, but that exception clearly does not apply here. Getting back to Justice Cordy's question, I would suggest that clearly the Superior Court judgment must be upheld. This was a statutory violation. I don't see what other remedy there can be. And I would also point out that with respect to whether there was any kind of nexus or any kind of special vigilance required to make this stop based on a default warrant, I would point out that in the map that is reproduced in the Commonwealth's Record Appendix of the BU campus, this location is not even on their own map. I would suggest that's a fairly important consideration.
Mr. Siegert, in the Young against Boston University case, the appeals court added the environs language, extends to the environs surrounding campus. I think that we probably can all recognize that we have many campuses in Massachusetts where there's the campuses extend over geographic areas, some of which are exclusively owned, used, occupied by the university, usually the main campus, and then there are all kinds of buildings around that are bought over time, and sometimes the only thing that separates them is a public way, sometimes the only thing that separates them is one small piece of property. Do you have any problem with the appeals court's interpretation of the land structures owned used? Used obviously means something other than owned or occupied. Do students going backwards and forwards between two buildings across some private land or across some public land, you know, the Cambridge Common or the Boston Common?
I don't have a problem with that interpretation at all. And I would point out that the BU policy guidelines, which are reproduced in the record appendix of the Commonwealth's brief, define the territorial boundaries of Boston University, including the medical campus. And as I pointed out, this particular location, this was a random license check at a gas station not on campus, on a city street, and it does not fall within that territorial boundary. It's not even on, as I pointed out, it's not even on their own campus map.
Was your brief filed in October of this year? I assume it was. There isn't a date on it that I can see.
I believe it was, Your Honor. This, I believe I filed it actually back in the appeals court before this case was taken sua sponte, back in December of '08, I believe.
Could I just address
Sure.
one thing? Mr. Zanini, I know that you're very overworked, and I appreciate that, and I'm sure you have a million other things on your plate. I know you do. But if the Commonwealth were going to disagree with its position in its blue brief, it would be helpful to us if you would let us know before today. Some of us spend some time reading it and then trying to think about it, and it wasn't really necessary.
Yeah, I'm explicitly disagreeing. I mean, there is an interpretation there which
Okay.
could be, woven mathematically. I put
Yeah.
it forward.
Okay, thank you.
Are there any further questions, Your Honor?
Thank you, Mr. Seeger.
Thank you.